Hey, all right, Shannon. You're right, Will. You're right, everyone.
Hello,
Welcome
hello.
to tonight's live stream. We have just been playing around with the whiteboard thing on our computer. So basically, someone made a very good comment a couple of weeks back on the live stream to say, is there a better way of kind of recording what questions we're answering? And we're going to try this out in a minute. So bear with us. It's the first time we've used it, and we're probably going to make some mistakes along the way, but I'm sure it's going to be all right. Usual sort of stuff. So it's not legal advice, and if you're putting questions in the live chat, I will not put them into the flip chart unless they are anonymized. So do not ask questions or do not write questions as if they're about yourself. Just ask questions as if they're about a hypothetical person. You'll get exactly the same answer and it will just help us keep on track of everything. Other bits and pieces. What else? There's a couple of LGO cases which were interesting this week. I'll go through them in a minute, but I'll get to that in a minute. Just for everyone, all the regulars, welcome. Please say hello if you're in the chat already. Nice to see who's here. Hey, you right, Nick? Nick's an early bird. Cool. And if you're new to the live stream, whatever, then it's basically me, Shannon, and Will going through as many questions as we can in the hour. We're probably going to overrun. We've had 14 questions coming this week, so there's a lot already. But basically, questions in the live stream we'll try and pick up as we go. And yeah, it's just a case of trying to give him helpful information. We'll try to give some sources wherever we can as well, so you can kind of go away with that and kind of refer to it in any correspondence you got with the council. Yes, that's the kind of idea of it. That's the gist of it. Shannon and I deliver training for homelessness best practice. The next date is the 10th of May, and the cut-off point for bookings is basically today or tomorrow morning, I think. So if you want to come along to that, it's very reasonably priced. Check out the Eventbrite link on the channel page or something. It'll kind of crop up. And the next one after that's the 14th of June. So I think we're pretty much full for the next one, but there's a couple of spaces. Other bits and pieces. So I've had a few questions come in from people just like direct to my email address. I don't know how people are finding my email address. Don't do that, please. It's not. Yeah, that's why we do a live stream, is so that we just don't have capacity to kind of go into individual detail. And there's a few other things I want to say as well. Yeah, let me just do the LGO cases for a second. So I'll put them into the live chat and then the description at the end, so you've then got them. But basically, there's one with Medway. It wasn't kind of groundbreaking or anything, so I'll just put it in there. So if you just copy and paste that into your search bar, it will come up. That code. And basically, this is about a private landlord who was not carrying out repairs, and the individual here complained to the LGO that the council hadn't taken like the right steps at the right time to get the landlord into line. And they only got a couple of £100 compensation, but it's just an interesting case just to kind of understand how the law works, because in LGO decisions, they always explain what's actually going on and kind of a law behind it. And then there's another one involving Kirklees, which I think sounds like it's near Liverpool. I might be wrong about that. But that's basically a domestic abuse case where the council basically left this individual homeless and at risk. So again, it's just kind of an interesting kind of exploration of how the law works there. Yeah, Shannon or Will, I know Shannon's got a bit of gossip this week. Will, have you got any kind of announcements or anything going on? You're on mute, but I'm going to take that as a no. Cool. Shannon, you've got some bit of news there. Do you want to share your screen if you want to, or do you want to just talk about it?
I'll just talk about it because, yeah, my screen is a mess at the minute. But we've talked previously on the live stream about the Supported Housing Act and how that will essentially change some of the housing law, particularly around intentionality, when the standards come out. Part of that act was that the government had to have a supported housing advisory panel. And that's going to be made up of like members from the Department of Levelling Up, MPs. Crucially, it's also going to be made up of people with lived experience of supported accommodation. So residents, I think they're also open to general applicants, like if you have an interest in it. It's £450 a day. I think the commitment's about 2 days a month. And there'll be meetings and discussing sort of like standards and anything related to supported accommodation, essentially. Pop the link in the chat because applications are now open. I think it went live yesterday. And you do have a few weeks to do it, but the application seems quite lengthy. So it's like a CV and person spec sort of statement and stuff. But yeah, I just wanted to put it out there because I know a lot of our viewers have lived experience, particularly around supported accommodation, and probably feel quite strongly about it. And it seems like a really good opportunity to make some real difference. So yeah, I'll pop it in the chat.
Yeah, and get paid £450 a day. That's pretty cool. Nice one. Thanks, Shannon. Yeah, cool. Okay, so we're about to go. We're gonna let me see how this all works now. Then, so as I say, there's gonna be a bit of screen juggling here, but if we get the whiteboard open, I'm hoping this will. Oh gosh, it's already given me problems. Here we go. Let's try that. Yeah. Okay. Yes. Right. This is the one. It's a bit zoomed out. How do we zoom in again? There we go. Right. So basically, the idea here, right? Yeah, as I say, this is a way of us hopefully keeping track of what questions are being asked, and kind of having a record after as like an index for people who want to actually check out, did they ask the question. So I've anonymized the questions that have come in when they've not been anonymized from the week. So you might not even recognize the question, which is another reason to kind of keep it anonymous, because the easier it is for us to kind of copy and paste it into this bit, the quicker you'll get an answer. So I'm just going to give it a second just to see what this looks like, because there's a 45-second delay. So I just want to see what this looks like on YouTube before we actually start. But we'll then basically get cracking. And as I say, bear with us if it doesn't work. I'm reasonably optimistic that it will. So let me get the first one just geared up, ready to go. So okay. So right, the bad news is that you can only see me, I think. So Shannon and Will, you're not on the YouTube thing right now. I don't know if I can do anything about that. Let me just change the.
Sure, people will be fine. I'm
Yeah,
sure
it might just. I've just changed the screen around, see if that does anything different. Okay, but anyway, so first question we've got coming in, if I can open this one up. No, I can't. Here we go. Is this one here. So, and again, let's just zoom in to make that more legible. Hypothetically speaking, following a section 21, that's notice to quit, if a council emails and tells a family to find their own private rented property, and the council will allow them to retain band 2 on the council waiting list whilst in the private rented sector property, I should say, and pay the upfront costs such as deposit, first month's rent, can the council be trusted? Sounds too good to be true. So, interesting question. It's not something I've seen councils do, from individuals I've kind of seen progress, but it's something that the council certainly can do. And what there's basically, essentially what the council's doing here is they're realizing it's cheaper for them to do something like this than it is to, to kind of put people through the existing system. So in one sense, that's the kind of background for it. And I think the question is, can the council be trusted? I would say not unless they put it in writing. So I think in a situation like this, you want to make sure you've got absolutely concrete assurance from the council that they will follow through and that you will remain in the corresponding band here. So it's band 2 in this particular person's case. And effectively, you treat the private rented sector property as temporary accommodation. I'm not, councils don't have to do this. So in one sense, it's a good sign that the council's actually looking to kind of make things a bit fairer, because essentially what the council's trying to do here is to not disadvantage people from accepting private rented sector properties, because quite often if you accept a private rented sector property, normally you're no longer homeless, you shouldn't be in any housing need, and so you'll usually come off the housing register altogether. So the council's here is saying, we'll keep you at band 2 because it's in our interest to do so. I think that's essentially what's happening. So Will and Shannon, you got anything to add to that one?
Not really. I was going to add that point about is it in writing, but if they put it in writing, you can rely on it a lot more. But they're not actually offering anything material. They're just saying you can stay in band 2, aren't they? Really. So it depends how good band 2 is. But it may be better, and the implication is that you might want to check what would happen if you did take temporary accommodation, whether that would mean that you went down to band 3 or something. But presumably you've looked into that. But it sounds like it's something you could rely on if it's in writing.
Yeah, cool. Okay, so I'm just doing a bit of I'm just looking at the live stream as well. So someone's just saying they can only see white screen and whoever's speaking. I'm pretty sure that now the text is in there, you should be able to see it. So if anyone could just put a shout out into the chat just to say it's working, that'd be helpful.
So when it's highlighted, you couldn't see it, but once you've clicked off it, then it shows up as text. So you just need to make sure that once the question's in, you've almost clicked off it, and then it updates it, if that makes sense. So
yeah, cool. No, that's all right. Thanks, Shannon. So yeah, let's just keep going and see how this works out. So again, let me just zoom in to make that kind of bigger. And also, if I just change the shape of that, it should kind of. I don't know. It's not gonna. I'm limited to what I can actually do here. It's not allowing me to kind of do exactly what I want to do with it. But let's see what that works like that. Yeah. So hey, you're right there. So the person, yeah, we are live, so we will get to the live stream in a second. As I say, we're just playing around with this thing. So next question, or that's saying 1, 2, but anyway. So what if someone was given the key to emergency accommodation? They're pregnant and homeless on the 29th of February, as an example. Is that when the relief duty starts? Her homeless prevention officer said that he didn't pull the trigger until the 6th of March, and the relief duty didn't start until then. Is the housing officer just trying to gain more time? The housing officer has accepted the relief duty is now ended. So the maths of it basically means that even if the relief duty was accepted on the 6th of March, it would still have ended now. And so basically the housing officer is kind of able to not accept the relief duty straight away. So you make the homeless application, you give the council reasons to believe that you might be homeless, might be eligible, might be homeless, and ask the council for help, should I say. And then you get interim accommodation if you give the council reasons to believe that you might be homeless, might be eligible, might be priority needs. But the relief duty does not start until the council is satisfied, as in, they are, reasonably sure that you are in fact eligible for assistance and you are in fact homeless. So it's not unusual for there to be a delay between making the application and the relief duty actually starting. It shouldn't be more than a few days. So I'd have thought 7 days isn't outrageous. Certainly if you've been there weeks and the relief duty is not started or anything like that, then that's definitely cause to complain. But yeah, in this situation, that's just how the relief duty works. So there is a little bit of delay. So the council won't be able to make their final decision in this case until day 57 of the relief duty starting. So the day after it finishes, basically. So hopefully that makes sense.
Just to add, it doesn't stop other things from happening though. So things like getting all the documents together for, say, the housing register, or looking for private rented sector accommodation, like all of those other things, particularly like around PHPs and stuff. Am I right in saying that doesn't stop just because one duty hasn't started yet? Like you can still be doing things, if that helps at all.
Yeah, it will kind of depend on how efficient the council is, basically, in terms of kind of doing those other things. But yeah, so sorry, I was trying to multitask there, Shannon, so I didn't hear exactly what you said. But the duty, I don't know if this might have been completely off the wall, what I'm saying here, but basically, once the council is satisfied that that you are homeless and you are eligible, there's basically two things that actually technically happen simultaneously. So there's a duty to carry out an assessment and do the PHP, which technically speaking, although it makes no difference in the real world, is happens at the same time that the relief duty starts. Although technically the assessment and PHP is not part of. I've only found this out this week. It's not actually part of the relief duty. So as I say, for all intents and purposes, it is, but that's the kind of way it works. So as I say, I don't know if that was what you were just talking about there, Shannon. So apologise if that was just nonsense. So yeah, let's see how. Right, okay, it's working now. Good. Okay. So let's answer the questions coming. So, oh my gosh, I need to get another screen here. But anyway, so as accommodations whilst waiting permanent, let's get right there. So as accommodations whilst awaiting a permanent one, i.e. social housing, which is a better position to be in temporary or council lets, pros and cons? Thanks. Okay, so every council does this all differently, which is why I'm just trying to work out exactly what position the council's taking here. So let me go back to basics for a second. So let's assume that you're in interim accommodation. The council then, you get through the relief duty. So nothing happens to the relief duty. You get through the relief duty. The council issues a main housing, the final Section 184 decision, as in the main housing duty. So they say, yes, we have a duty to basically help you into social housing or a 12-month assured short hold tenancy in the private sector, which is still on the table at that point. But you're now in temporary accommodation. Now, in terms of the difference between temporary or council lets, I think what we're probably getting into here is some colloquial stuff that probably isn't. These aren't legal terms. There's the kind of the council lets. If I think what you're talking about there is like nightly lets or kind of procured housing through the council or something. That's kind of what I'm taking that to mean. Legally speaking, because there's no real legal distinction between those two things, I don't think there's really any difference for people in that situation as to what it kind of, in terms of timescales or what it's going to lead to. It might be different in terms of your experience. It might be better quality or worse quality, but that's how I would take that question. So, Will or Shannon, have you got anything to add to that one?
So I read it differently. Because again, like you said, I think it's potentially like locality and phrasing that different areas use. I took it to mean as in like interim accommodation that is owned by the council, or interim accommodation that's owned by, say, like a landlord and is rented out to the council. That's what I took it to mean. I could be way off base here, but again, think it swings and roundabouts, which isn't a very helpful answer, but it's going to just depend on the accommodation itself, on the landlord, on the quality that the council's, deciding to put into temporary accommodation. Think whilst you're waiting for social housing, and obviously depending on your situation, it's probably important for us to mention that you might not be guaranteed social housing, and the council can give you private rented housing as like a solution. I don't know what else would the pros and cons be, but that's how I took it. But I might be way off base.
They just clarified it a bit further, but I think we're along the right lines. But yeah, Will, do you kind of have any kind of perspective on this?
I think this is another problem with the labels, isn't it? Because permanent, I mean, obviously, again, permanent accommodation, there isn't actually a right to permanent accommodation anyway, so you wouldn't be waiting for that. Or you might be, but you're unlikely to get it through the homelessness route, because all they have to do is secure that suitable accommodations made available, which could be private sector. And then I agree with Shannon. I think the only analysis I can make that makes sense of the question is what Shannon said, which is that you're looking at temporary accommodation provided by the council or temporary accommodation provided by a private landlord. And I would think there's not an awful lot in it, except that maybe it's better to have a council landlord because they're more accountable. So yeah, that's what I would add, which isn't much.
Yeah, and I don't know if there'd be any significant difference in costing at all. Because again, it's kind of, the council can't charge you more than you can afford anyway. So, but it might be, from the council's point of view, it might be different because they certainly nightly lets, they pay them through the nose for them. So, but yeah, I think from the point of view of someone actually going through that process, I'm not sure what difference it makes. So yeah, sorry, we can't be more helpful there. Just next question coming in here. So what if someone was moving out as a result of domestic abuse and was waiting for the MARAC, which is the Multi-Agency Risk Assessment Conference meeting at the end of the month, but also has the option to submit a homeless application via domestic abuse to their council? So this is a really good question. I'm actually thinking about doing an event, like a specific event on this kind of stuff, because I can tell you what the legal answer is, but actually it's going to vary massively depending again where you are, what kind of services you've got locally. So the law is the same across England, but the councils kind of vary massively in terms of how good a job they do with responding to domestic abuse. So the legal answer here is, if you are at risk of domestic abuse in your own home, legally speaking, you are already homeless. You do not actually have to flee to be homeless. You're already homeless. Therefore, at any time of the day or night, you can contact your local council and say, I'm experiencing domestic abuse. Can you help me out with housing? That triggers a homeless application. Assuming you're eligible for assistance or there's reason to believe that you might be, the interim duty to accommodate would also kick in again any time of day or night. And that needs to be suitable accommodation that's suitable for you and your household, that's safe. Now, having said all that, in my opinion, the homeless application process is this kind of safety net backstop, kind of underlying thing that is going to be there for you. However, the MARAC and IDVAs, because if you're discussed at the MARAC, you will have an IDVA, so an independent domestic violence advisor. So they're a professional who kind of they've actually got reasonable amount of training and stuff. They're actually quite competent a lot of the time. So their kind of job is to kind of help you out part of this. Certainly, in my experience these days, you only get like a month's worth of support. It used to be a lot more open ended, and they can look at other options. They can look at making your home safe. They can look at there would be situations where, for example, it might be possible to kind of get rid of the perpetrator, one way or another, so get them off the tenancy, potentially, those sorts of things. So there are some things that can be done as well as a homeless application. But certainly, if you're at risk of domestic abuse now, I guess the textbook answer is to say don't wait until the MARAC has their meeting in a month's time. You can make a homeless application now, and then you can always return to your property potentially. There's nothing stopping you doing that down the line. So that's something to kind of, I guess, just discuss with your IDVA. As I say, in my experience, if you know you're going to be discussed at a Marek, you will already have an IDVA. Someone, they would have told you that, or certainly some professional would have told you that. And kind of you can talk to them. And again, I would be really careful about making decisions. I would ask for written advice from everyone you're dealing with. What are the implications of this and that? What's the cost implications if I move out? You probably also want to be telling your landlord in the process of doing that as well, in terms of just alerting them to what's going on. There's a lot of things you probably want to do that, you can potentially make joint claims in terms of housing benefits. Also joint claims. You can make kind of, double simultaneous claims for housing benefit, so that you're not out of pocket. There's a lot of things that could be done. But I think my short answer would be, don't wait until the end of the month for the Marek to happen before you actually get help. If you're at risk now, then approach the council for help now. Technically speaking, they should have already done this with you, but they probably haven't. So yeah, that's my answer to that one, guys. Anyone want to add anything to that one?
No, I think you said it all.
I think I just want to add, it's important to also have the conversation around location. Because I know certainly in Bedford we saw it quite a lot, where police and professionals were giving like a bog standard, you have to be moved 50 miles away. So in that Marek meeting, if you can bring sort of the location of where you feel safe, where your network is, all of that, because when you do make that homeless application, that will become really relevant. So that's one thing I'd add. And then I guess just, again, around location, is you can make a homelessness application if you experience domestic abuse anywhere. So again, it's worth thinking about where you want to make that homelessness application. I'm going to assume it's the same area because you're in the Marek in the same area and you've got what seems like support. And like Mike says, that varies from area to area. But yeah, location is something that comes up as a blanket by local authorities quite a bit. It's also worth, ahead of this, I think, checking out the local allocations policy for your area, because sometimes, believe it or not, domestic abuse survivors get punished for making a homelessness application and will either get absolutely no choice in where they move to, or get sort of bumped down the list, but they're still higher than other people, but really they're not. So it's worth just checking out the housing allocations policy to see where you might fit in with that. But yeah, that's all to add. Sorry.
That's a really good point about the just checking your housing allocation policy. So if you just Google it, Bedford Borough Council housing allocation scheme, it will come up. And as Shannon says, we've seen quite a few areas now which have a policy which means if you make, if you stay in your own home and you get abused, you'll get band A. But if you make a homeless application, you go down to band D or band E, which is nuts. Any professional should be challenging that sort of policy locally. There should not be any policy like that around. It's actually quite straightforward to challenge those kind of schemes when they come up for renewal anyway. So if you're a professional working in this sector, you should be aware of your local policies, and you should be using the consultation kind of periods and stuff to give that sort of feedback. In Bedford Borough, Shannon and myself, a few years back now, I think we asked for 15 changes or 16 changes, and we got one less than we asked for, basically, in terms of kind of getting improvements and how they were dealing with all that stuff. So, in one sense, it's common sense stuff. And if you make it public and go to a housing committee or something and ask these questions, then you'll get taken seriously. Cool. So, just trying to make sense of this question here, but it's just come in. So the private rented sector property you're in is sold, and the Section 21 has expired, but the possession order hasn't been ruled on yet in the courts. The council insists the family find private rented sector property on their own. So this is gatekeeping. You want to complain about this, the council can go and advise you to say, yeah, go look for private rented properties. The housing officers who say that know full well that there's hardly any private rented sector properties around that are going to be affordable for you. And the code of guidance is very, very clear. So if you go on the YouTube, like this YouTube channel, I did a video maybe 3 weeks ago entitled Section 21's bailiffs. Can't remember what else is in there, but if you just search for Section 21 on this channel, you'll get a video which explains this in detail. So basically, the long and the short of it is the code of guidance, which is the rule book for council, says that it's unlikely to be reasonable to continue to occupy once the Section 21 has expired. And that really means, there needs to be a very good reason for the council not really accepting your homeless at that point and potentially placing you in interim accommodation. If you look at that video on the channel, I've put some LGO decisions in there in terms of kind of examples of where someone's got compensation for that sort of thing. Even when landlords have got compensation, where as in the landlord gets compensation from the council because the council told their tenant to stay put after the Section 21 expiring. we'll try and we've got a lot to get through. So that will hopefully contain the answer you need around that. Good question coming here. Are there any forums or pages of successful suitability review stories? Yes, there are. Really good question. So the first one I'd say is if you go to lgo.org.uk, it's the local government. Well, these days it's actually called the Local Government and Social Care Ombudsman, but I still call it the LGO. But if you go in there and you basically somewhere on, let's do it. Let's just do it. Hold on. Right, let me get out of this for a second. Hopefully we won't lose that. So share screen. Just bear with me a second.
I've also popped it in the chat, and just while Mike's finding his screens, I popped the video for the section 21 in the chat as well.
Thanks, Shannon. So if I go to, oh gosh, I can't actually see what's going on here. It's not letting me do it. So right, so take my word for it, guys. If you go to lgo.org.uk, on the home screen it says something like search our decisions or search our findings or something like that. So yeah, do that. Once you kind of get that, you get to another subcategory which will kind of say, social care, education, housing and homelessness or something. So it kind of is quite logical. You'll then basically be able to go into the archive of all homelessness decisions going back however many years. And in that, there, you probably won't be able to screen for suitability exactly. You'll have to go through all of them, but there'll be plenty of decisions on there, which is about suitability of various types of, suitability reviews, basically. So that's one really good resource. Another one is a blog called Nearly Legal. So nearlylegal.co.uk. It's done by Giles Peaker, who's probably the most famous housing solicitor in the country. And again, he's got an archive of lots of decisions. Now, for example, if you search for the letters YR and Lambeth in that, to be honest, if you just put that into Google, it will come up with Nearly Legal. But there's kind of expositions of these cases where it's gone to the court. So the LGO is kind of when things don't go to court and they kind of go through the complaints process, and Nearly Legal will cover stuff when it goes through the courts. So you can, that's where I learned. I did not know any of this stuff 10 years ago, even though I'd worked in the sector, since 2005. It was through going to the LGO website and going to Nearly Legal and reading the code of guidance and getting a textbook that I kind of learned everything I've learned. So, hopefully there'll be stuff in there which you really kind of, the LGOs are really good kind of explaining the principles behind what's going on. They put it in layman's terms. So it's kind of hopefully something that you'll find useful. Cool, how are we doing? Wow. So let's see where we're going. Right, so there's someone just put a question in there about mental health relating to priority needs. So I'm going to answer that. There's another question that's coming through the week that will kind of answer that question. So I'm going to leave that for now. So I will answer it in a few minutes. Well, let's see when we get to it. But yeah, I'll kind of cover it anyway. So this one here. Go, come on, no. There we go. Right. So can council end the main housing duty because the applicant has been placed in temporary council-let licensed accommodation? Can this be classified as ending homelessness, therefore closing the case? So no, it can't as a main housing duty. But what might actually be happening here is they've actually ended the relief duty with a final accommodation offer or a final Part 6 offer, which might, to a layperson, they look like exactly the same thing, but they're not. So you need to go back to the letter that is kind of that's written in and just look at what kind of sections are mentioned. So if it says section 193 on it, that's the main housing duty. That's the really good one. But if it says section 18, I can't remember, section 189B, I don't know, I can't remember which ones it is now. But that's kind of a final accommodation offer. And basically, what councils will often try and do is, because at that point they're under to provide accommodation that's likely to kind of be available for the next 6 months. And certainly I had a case in a council I won't mention where they just literally palmed this family off into some useless temporary accommodation type setup. And the charity that ran it kind of specifically said, we'll make sure we house them for 6 months. And it was just a way of ending the duty. So basically, if you're owed the main housing duty, that is not discharged until you have a 12-month assured short of tenancy in the private sector, or you've got social housing, or you do something stupid in your temporary accommodation, get evicted from it. But that's the kind of only ways it would end. Am I right on that, or Will?
Yeah, yeah. I was just looking because I was trying to answer that one with a technical answer, but the duty under section 193 can only end in a certain limited number of situations, which are set out in section 1936. And those are that you cease to be eligible, you become intentionally homeless from your temporary, you accept an offer of accommodation under Part 6, that would be allocation of housing from the council. And then it says here you accept an offer of an assured tenancy other than an offer of an insured short-hold tenancy from a private landlord, or you voluntarily cease to occupy the accommodation. But the difference with that is with the relief duty, they can end that by creating a situation where you have accommodation available for you for more than 6 months, yeah? But I thought that they could discharge the duty under section 193 with an assured short-hold. But maybe I'm wrong on that. What do you think I'm missing something?
So again, I'm multitasking, so I missed a bit there. So I apologise. I'm trying to juggle some things. But so basically, this is so nightmarish. Section 193. That's what we all have always known as the main housing duty, which that's since the Localism Act came in. That's either going to be social housing or it's going to be 12-month to short-hold tenancy. However, with the Homelessness Reduction Act and the relief duty, if you are seen to have unreasonably refused to cooperate with either an informal offer or just those informal offers, basically a long story, but you're still owed the main housing duty. You don't get the normal main housing duty. You get basically a final accommodation offer, which would be a 6-month short-hold tenancy or a final Part 6 offer. I'm saying that out loud. It's ridiculous. How people are supposed to explain it or understand this is nuts. And I don't know what they were thinking when they made it. But so Will, I don't know how that sits with what you just said, because I actually missed exactly what you said. But so I think that would be my understanding of the only way a main housing duty could be discharged into a 6-month short-hold tenancy would be if they'd been deemed to have unreasonably refused to cooperate or they refused an informal offer of suitable accommodation. I don't know if that's what you just said.
What about a 12-month short-hold or longer?
Yeah, so 12 month, yes. So 12. So main duty could be discharged into a 12-month tenancy. Or as you say, or longer, but not a 6-month.
Yes, I'm sorry. I must be looking at a piece of a web page which has the old wording on it, because there is a square bracket around the bit that says other than an assured short-hold. They could. So to go back to the answer to the question is, they couldn't discharge it by way of placing them in temporary accommodation. It would have to be non-temporary, except that I suppose a 12-month short-hold is temporary in a way, isn't it? But it's not. It's offered as they describe it as permanent, but it's actually temporary. So that makes things even more confusing, isn't it?
I'm pretty confused right now.
Me too, yeah.
I'm trying to let's just kind of just wind back a second just to make sure.
Yeah. Maybe go back to the basic question.
That issue. I'm hoping what we've said already will kind of help with that question. As I say, my answer to that would be is that it can't be the main housing duty can't be ended that way. Until you've got one of those two offers. But I did another video recently. Will I get social housing or private rented accommodation on the channel? And about a week ago, I did one on the relief duty, or a few days ago, I did one on the relief duty. So watch those two videos because I do my best to kind of go through it. And I'm still working on the flow chart, which kind of graphically puts the kind of how these different things work as a way to try and explain this. No housing officers understand this either, by the way, guys. So don't worry about it. Don't think you're stupid. They don't know it either. If the local authority ends its duty because you refused an offer and are currently challenging the suitability, are you able to approach another council homeless by domestic abuse? Well, the short answer is you can always approach a different council, and I haven't worked in a situation like this. I'm trying to think how the second council would do it. So with domestic abuse, you're automatically going to be homeless, eligible in priority need. So you can approach any council in the country and they are going to have to provide you with interim accommodation. They'll then have to go through the relief period and kind of go through all that rigmarole. And then if they're going to say that you're intentionally homeless because you refused an offer of suitable accommodation elsewhere, that doesn't kick in for a couple of months. Now, as I say, I'm kind of talking just off my theoretical knowledge of this, I've not seen a case like that before. But I think that's that would be possible to approach a different local authority. You can essentially always approach a different local authority. They might try to refer you back to you're the first local authority where there's local connection issues. But I think with domestic abuse, the local connection doesn't work in the same way. So you might be able to I don't know, get around things basically. Shannon?
Yeah, I don't know. It's been a long week, so I think I'm being thick. But if that person was deemed intentionally homeless and they approached another council, would that council not say you're no longer fleeing domestic abuse? You're homeless because you've been evicted from temporary accommodation because of intentional homelessness decision. Now, obviously, that local authority can still overturn and make a new decision on intentionality and say they refused the accommodation because it was 5 minutes down the road from the perpetrator. The new council, you would hope, would go, absolutely, we can understand why, we'll accept a fresh application and go what have you. But my skeptical sort of like head on is the council would say you're no longer fleeing domestic abuse, you're now homeless because you've been evicted from. Yeah, am I wrong?
No,
Or
no, 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 no. I think that's a very. I think that's that. Yeah, there's a lot of sense in it. I would come back and say, well, technically, at that stage you've only presumably been in interim accommodation in the other
that's
local
not settled
authority.
accommodation.
Yeah, so you can't.
Yeah,
So I would still argue that you're homeless because of the. But I don't know that I wouldn't be surprised actually as well if there's actually something specific in the code of guidance which covers this particular kind of potential possibility. So I might need to go into that in the week and just kind of have a little look if there's something. I can't remember exactly how it kind of works out. Really good question. I mean, yeah, short answer is do it anyway, even if you don't know that you could do it, because it's better than being presumably at this point ruthless. Um, if I get 2 seconds tonight, which isn't likely, I might be able to kind of come up with a bit in the code of guidance that talks about this because in one sense, if you refuse a offer of suitable accommodation, I'm not sure you're actually technically intentionally homeless at that point. I don't think it quite works like that, but I can't remember. I don't know.
I think
Yeah, I
we've
need to look.
had this conversation before, haven't we? Because I agree, I don't think you are intentionally homeless. You have to go back and apply somewhere, possibly even to the original local authority, and say, hello, I'm homeless because you're cancelling my temporary accommodation because I refused an offer. They've got a choice when you do that. They can either say, sorry, we're not processing your application because we've already dealt with you, which I think would be unlawful. Or the alternative, which they could do almost immediately, like they could just fill in the blanks on the word processor, is to say, we're not helping you because you're intentionally homeless, because the reason you're homeless is because you refused an offer of accommodation, which led to the termination of your previous accommodation. Then a couple of questions kick in then. One is this issue of domestic abuse. If the issue of domestic abuse was relevant to the refusal of the offer, then that might be a reason for challenging intentionality. If you were at risk of domestic abuse at the temporary accommodation, which you lost, then it might be grounds for challenging it on the basis that you couldn't have become homeless because it was unsuitable. And in any event, if you're in priority need, which you presumably would be because you got offered the accommodation, and if you got children, you're then entitled to say, well, I need assistance under section 190 of the Housing Act 96 because you have a duty to people in priority need who are intentionally homeless. Plus, you have a duty under section 17 to ensure that my children don't become homeless. So you can not only approach another authority, but you could approach the first authority. That's my view.
Yeah.
so there's
Okay.
been some more added in the chat with this question. So the offer was
Okay.
250 miles away from friends and family who support with 3 young children. So I think because of that, it would be easy-ish to
Yeah.
challenge the fact that you haven't refused a suitable offer of accommodation. And things like requesting access to all of your records, so doing a subject access request, because in that, the council have to bear in mind and take consideration of every member of your household, and that includes your children. So if they haven't considered how will it affect your children, then that's something that you can also challenge and complain about. And again, looking at your personal housing plan, seeing what the council have said in relation to your children there and distancing and stuff, it's worth getting a copy of that, challenge and complain first in this instance, whilst you're waiting for the copy of records.
Yeah, I mean, if there's not, if that assessment hasn't taken into account, so essentially for a council to get rid of you in that sense, they'd have to have written how they've carefully assessed the needs of your children in relation to the caregiving, you know, kind of in the local area, and they would need to have kind of provided some kind of rational reason why they still think 200 miles away is reasonable. So I think, yeah, I think there's a lot of grounds to kind of, you know, to think you've got a good case there, but with councils, that doesn't really necessarily mean anything if they're just being perverse. So I think, again, if you could find a solicitor, it would be a very good time to do so. And again, just to kind of, you know, be a broken record, Will's got a website with a load of legal aid funded housing solicitors on there, but it's likely a lot of them will be at full capacity, so that might not actually be very helpful. But if you can't do that, then keep going down your line, you know, keep reaching out to local politicians and stuff, because your central argument is it's clearly not reasonable to be moved 200 miles away when, you know, when your children have got local kind of, you know, kind of care responsibilities, or, you know, receiving care locally. So yeah, I hopefully within all that complication, I'm hoping there's something that which was kind of, you can kind of find useful. There's some questions coming in about so vulnerability and priority needs. So I'm going to kind of try and deal with them all together, just kind of based on the question that's coming through the week. So Claire, just a question. I put the link to that Lambeth case in there, so the nearly legal link, which is that specific case about suitability. So I'm just making the point that it's really hard to prove domestic abuse. So, and yeah, and that kind of, just to reiterate something we've said quite a lot here, the Homelessness Code of Guidance, which is the council's rule book they have to follow, says very clearly that councils can't have a blanket approach that requires police or corroborative evidence from professional, because there's lots of different situations where you won't go to the police or another professional for, you know, for various, you know, sound reasons. So, and also the local government ombudsman did a report on domestic abuse in 2021, which is worth Googling. It's like a focus report, and that basically makes the point that council's default position should be to believe people who've been victim of domestic abuse. That's page 14 if you want to find that report. So let's do I think realistically, guys, we're not going to get to do all the questions tonight, so I'm going to just sideline the live chat for a second and just start crunching through some of these questions that are coming through the week. So, but I'm going to start with this one on vulnerability and priority need, because I think it kind of answers a couple of people's questions. So if I just bring that up and stick it in there. So this is a very specific question, but I thought I'd put it in like this. So hypothetically, obviously, because it's hypothetical questions, but if someone had the emotionally unstable personality disorder, depression, suicidality, which I would take to mean someone who is, you know, kind of at risk of committing suicide and, you know, thinking about it a lot and kind of, you know, in that sort of place, anxiety and psychosis, and they're taking these medications, would they be in priority need? Now, the short answer in this example I've given here is yes, they definitely would be, but it's not definite in this kind of world. So just because you've got, you know, just because you are very clearly very, very vulnerable, you still have to go through the kind of steps of proving your case. Proving the case is not the right words, but the kind of, you know, showing why that is. Now, I just want to go into a bit more detail here, just to kind of give you an example of something you can do. So if we go to browser somewhere, and well, there we go. So basically, so it mentions three medications, olanzapine being the first one. So this is the British National Formulary. So BNF.
You've turned your camera off, Mike.
Oh gosh, don't have to turn it back on again either. You can still hear me. We're still fine. Yeah,
loud and clear.
Yeah, cool. So yeah, so basically this is the BNF. Just Google it for nothing. So it's basically an encyclopedia of medications you're going to get, and the reason it's good to research this stuff is because your doctor might not have actually told you what your exact diagnoses are, or what, you know, what's kind of going on at the moment, and so yeah, just this is a really good resource. So for example, this person said they're on 20 milligrams of olanzapine. You know, that in this case it could either be for schizophrenia, bipolar, mania, or kind of, I think this is kind of what we would call a mood stabilizer. I'm not quite sure. But you'll notice here it's got the kind of doses. And so from sometimes, let's go to a different one. This is not easy because the way Zoom is at the moment, I can't actually see my whole screen. So propranolol's mentioned. So again, you've kind of got this kind of thing of like, look, propranolol's prescribed for lots of different things. So you kind of work out, okay, well, in this case, it might be anxiety or something. So again, so 40 milligrams once a day, then increased if necessary to 40 milligrams 3 times a day. So that's a maximum dose of 120 milligrams a day. Now, if we go back to the actual question, you can kind of get a sense of like how serious the doctor thinks it is. Now, it's not kind of a exact science with this, but I've made a lot of priority need to see kind of arguments by quoting the BNF. Yeah, persons on X, Y, and Z medications, and I'd go to the BNF and I'd say, well, clearly these are high doses, so this clearly is not something which is insignificant, and that again doesn't actually win the argument yet, but it lays the ground for you, showing that you've got something about you which differentiates you from a so-called healthy and robust person. That's the legal test as it's written. So let's get back to this. So in one sense, in this case, particular example we're seeing here, you kind of, you list all these issues. You would ideally get medical, you get a letter from your doctor or psychiatrist or community psychiatric nurse. And you basically, the key thing here is you'd want evidence of what's likely going to happen to you if you become homeless. And clearly all these things are going to get worse. You've got EUPD, depression, anxiety, psychosis, and, kind of risk of suicide. All of those are going to be, massively increased in terms of risk if you become homeless. So it shouldn't be too difficult to get professionals to write that down. Unfortunately, you kind of have to do that because lots of housing officers are really stupid and perverse. I've had housing officers, it's a story I tell a lot. Someone had his medication nicked. He had olanzapine, I think was actually one of them. So an antipsychotic, and he had his olanzapine nicked, and the housing officer said, "Oh, well, you're not taking any meds, so you must be fine." And it's like, you're a moron. But those, unfortunately, there's quite a few morons in the sector. So that's this specific example. So going back to the kind of questions that someone just put in, I think there's stuff about other health issues, but that's really what you're trying to do with priority need. Is you're first of all really kind of trying to show how you're different from a healthy and robust person. So, something that's significant about you, which a healthy and robust person wouldn't have. And by definition, a healthy and robust person would not have these issues. That's essentially that you're comparing yourself against a hypothetical person with no issues of any kind, and you're trying to work out what difference is that going to make to you if you were to become homeless. So that's kind of hopefully something which is half helpful.
Can I add a couple of things there?
Yeah.
So just because, again, I've seen housing officers say, well, you're on all that medication, you're engaging well, so you're fine. That's also not the test. So just because you're taking your medication or just because you're engaging in therapy, that again isn't the test. It's as if you weren't on all that medication. It's also worth highlighting to the council that you have a disability. Now, I know some people feel uncomfortable saying they have a disability, and that's something that hopefully a worker would sort of talk the client through. But in this sense, it could really help sort of your housing application, because when it comes to them looking at suitable accommodation, when it comes to them looking at temporary accommodation, they will have to take that disability into account. And when you've got things like anxiety, EUPD, who knows how that might sort of affect you, whether you might need, sort of temporary accommodation with your own front door rather than shared accommodation, or whatever it might be. All of those things you need to sort of lay out, not just the disability, how it affects you, and any reasonable adjustments that they might need to make. And that could be something as simple as, please don't ring me, I need everything in an email because actually I can't answer the phone. It might be something slightly more complicated. Whatever it is, that's okay to tell the council that. Yeah, that's all I wanted to add, really, I guess.
No, that's cool. Thanks. That's all helpful. Yeah, I mean, yeah, there's probably a lot more to say, which we're not going to have time to say tonight. But as I say, it's the threshold for vulnerability is not terribly high by definition. It's not. But yeah, in one sense, it's the easiest thing for housing officers to be perverse about. So if you it's very difficult to say that the kids don't exist if you've got dependent children or something, therefore you're in priority needs. But vulnerability, so health issues, that kind of thing, that's the easiest one. And in one sense, housing officers use templates, and the template will essentially invite the housing officer to list all your health issues. Then there'll be a sentence saying, I've carefully considered all your health issues and I've concluded that you're no more vulnerable than an average healthy and robust person would be if homeless. And it's just they haven't even engaged their brain. They kind of that's what you're up against. So yeah, it's unfortunately it is very difficult. Getting a solicitor is going to be a real kind of key thing. Again, just trying to kind of pick, yeah, I'm picking and choosing the questions I'm answering here a little bit. So just a quick one here. So if a person's got to go to a council to be assessed, what kind of interrogation is to be expected? That word interrogation is probably not that inappropriate, to be honest. Some housing officers will make you feel very uncomfortable. They will be bullies. They will be just horrendous people. If you haven't got someone to go with you, then I would suggest you try and find someone to go with you. If you can't, if it was me personally talking for myself, I would covertly record the conversation with the housing officer. It's legal to do that as long as you kind of keep that recording safe and only use it if you have to. But it's potentially going to be a rough ride. My experience is more often than not it's a rough ride. You do still have decent housing officers for sure who are incredibly good, but that's not the norm, I would say. So yeah, I think just prepare yourself for a rough time. It's fine to say, look, kind of this is getting a bit too much for me. I need to go and have a 5-minute bit of fresh air or something. Yeah, and don't lose your shit with them. Basically, that I've seen housing officers just try and provoke people. Just try and get them angry, so then they can say, oh, they're angry. They were being abusive, so we're not going to help them. So just make sure you don't lose your cool. Just walk out is fine, but don't shout at them. Don't be abusive, even if they, quite frankly, deserve it sometimes. Another quick one in the chat. Friend was gatekept by council through rough sleeping pathway and refused help. What is the process for making a complaint? Really good question. Let me just stick that into the little thing you've got here. So I guess Google your council's complaints process, first of all. It should be readily available on the council's website. But once you've read the council's complaint policy, ignore it to some extent, because your first stage complaint is actually going to be, you want to send it to the chief executive of the council, not go through the normal route, because you basically, if you send it to a complaints team, that's their bread and butter. They don't care a lot of the time. Whereas if you go to a CEO and you're kind of making a robust kind of argument, then you're more likely, it's not guaranteed, but you're more likely to get a better result. And also copying councillors and whatever else. In my experience, council officers do really fear councillors. If a councillor starts asking questions about a client situation or constituent, they do tend to panic a bit and kind of run around and give that person a better service. So yeah, that's kind of my advice. And again, complaints process, in my experience, you're not going to get a decent outcome for a year. So although it might help in the short term, you're not going to get compensation for a year. That's how long it really takes, to be honest. And you're going to have to probably chase the council because they won't respond to you in their own prescribed time limits. You might also want to get a subject access request, like Shannon said earlier, about kind of requesting your records, which again, you're probably going to have to chase. Last few ones I've done, I've had to complain to the council for not providing it within the legal time limit. So it's just hard work. That's the bottom line. Shouldn't be, but that's how they're kind of dealing with complaints, I think, a lot of the time. So what if someone has been given 2 months notice? So someone's in supported accommodation here. Let me just put this into the thingy. So what if someone's been given 2 months notice to leave, having stayed in supported accommodation for 18 months? What help can they get? So this is not an unusual situation. Lots of supported accommodation projects around the country will have a maximum time limit. However, and Shannon's probably going to help me out more than I do about this, but essentially supported accommodation will fit into one of two categories. One will be kind of registered providers, where they're often commissioned by the local authority, and other ones are like non-registered, so unregistered providers, and they tend to be proper cowboys a lot of the time. So if it's a registered provider, it's possible, in fact, I say it's likely, that there is a specific kind of agreement with the council in the housing register to say, if someone's been in supported accommodation, they're doing well, we will kind of give them band 2, band B, whatever, if they've stayed for a certain amount of time. So that might be a possible thing. And it's entirely possible that the staff actually won't know this, because they get paid if they get paid whether or not they actually do a good job most of the time. So you might just have to dig around. It's probably worth just writing to the manager and saying, what are you guys going to do? Because, that's your job, is to help me get housed. But if they literally, I don't think this is going to happen, but if they were literally going to kick you out because the 18 months has elapsed, then you can make a homeless application. And again, then it all comes down essentially to whether you're in priority need or not. as to whether you're actually going to get anything that way. And also, I'd also hope that a staff member in support accommodation would have helped you get onto the housing register at the moment anyway. So that might save a little bit of time down the line. So that's kind of, there might be other, what happens in reality is a lot of people will just jump from one supported accommodation project to another. And each time the charity running it will claim it as a positive move on, but it's not positive at all. It's just, they're just playing a game with it really and kind of making money out of people. So that's that question there. I can't even see the live chat right now, guys. So I'm going to just kind of storm through these questions as quickly as we can. Next one, another good question coming through the week. Can you do a timeline of when things should happen within the 56-day relief period? There's actually no prescribed kind of things that have to happen in the relief period. The council does have to, kind of have done an assessment and have made a personalised housing plan, but they don't actually have to do anything else. They can just do nothing. And then when the 56-day period ends, if you're not in priority needs, that's it. They'll wash your hands of you. That's the end of the process. But if you are in priority need, then you're either going to get the main housing duty, or you're at least going to get the Section 190 duty, which Will mentioned earlier, which is the duty to people who are in priority need but not but who are intentionally homeless. And in that case, you're going to get about another month or so of housing in real terms. So that's another question. Right, another question, quite a few questions coming about the relief period from different people here. So again, I'm just going to try and run through this as quick as I can. I've now run out of free-made slots. So what if someone is in the relief period and has been told by the council they are eligible, in priority need, have local connection and not intentionally homeless? The housing officer says they need to wait 56 days until anything can happen. Interesting situation. This is not actually a bad situation to be in. It's not legally correct. However, that actually says to me that's a housing officer with a heart. They basically said to this person, look, I can't formally accept the main housing duty to you yet, but if you wait 56 days, I can. That's actually probably quite a good position to be in, because it's not actually technically correct, because in the relief period, they are supposed to help you, take reasonable steps to get you housed. They should be, trying to make final accommodation offers within that period. But the fact this housing officer said this says to me that they're not trying to do that. They're just going to try and let it run, let the main housing duty kick in, which is the best outcome in my opinion. And hopefully that will actually be a good end to that situation. Man, we're only, oh man, right. Will and Shannon, if you need to go, just head off. We're not even halfway through yet. Next one, how long does the council take to respond to a homeless application? So they have to provide interim accommodation if there's reason to believe that you might be homeless, might be eligible, might be in priority needs. But if that's not the case, then it's very difficult to pin down a council. There's no kind of specific time limit within the kind of guidance or the law that says they need to do X, Y, and Z. So a competent council which is working efficiently should immediately acknowledge that the homeless application has been received, and they should basically make contact as soon as possible to start the assessment into whether or not you are eligible, whether you are in priority need, and if there is reason to believe that you might be homeless, might be eligible, might be in priority needs. But there's no kind of actual, you can't point to a number and say it's been 3 weeks, you haven't done anything, get to it. Although if you did take a complaint to the LGO and said it took them 3 weeks to respond, the LGO would say, yeah, that's maladministration, that's not good enough, and you might get £100 compensation for it or something. Oh man, how are we doing, guys?
To that, because there's been a few questions in the chat around priority need again, and if I've got this, or if I don't have a diagnosis of autism yet, or if the person doesn't have this, or if I've experienced this. And I just want to highlight what you said there about reason to believe you may have priority need, because a lot of the questions about will I get temporary accommodation, and so it's so important, guys, like that threshold is so low. That reason to believe is if you've told them that you have these conditions, that's given them reason to believe that you might be in priority need. It's not an absolute. They don't have to have done their assessments at this point to give you interim accommodation. So yeah, I just wanted to bring that in while you're working out the next questions, because I think it hopefully answers a couple that have come through the chat as well. Yeah,
cool. I'm going to do a video about same day non-priority decisions at some point, because they're not okay most of the time either. Another question here: can you get legal aid for housing law? You can if you're really lucky. So technically, it's available. as I say, if you go into this channel, the videos that these live stream videos, I put Will's website into it, which has got the kind of list of housing kind of legal aid funded solicitors. But yeah, a few months ago, someone on the live stream just basically rang around and tried to get someone, and they all said that they were at capacity, so it doesn't actually necessarily solve anything. If you can vote, if you haven't voted yet, by the way, guys, today's a good day to vote. If you've got local elections going on, about any candidate who seems to care about housing and stuff is probably a good person to vote for. Right, yeah, I'm going to keep smashing through these ones we got in through the week just to get through them. So again, there's a few simple ones which I'll just kind of knock off. So next one is about the banding system on the housing register. Do they take into consideration the time in the banding on the housing list? Yes, they do. So essentially, everyone in band B, again, gold band, whatever, everyone in that band will basically be then prioritized according to their registration date, as in the date they got that banding. So someone who got band B in January would get precedent over someone who got band B in February. So the longer you've been on the kind of system, the more priority you get, the more, essentially there's kind of like a waiting list. Having said that, you might be winning bids even, and housing associations can still turn you down if there's something about your situation which they don't like. So if you've got rent arrears, for example, or some sort of something they just take exception to, you might be winning bids and still not actually getting housed. So there is kind of a shortlisting process which goes on. Shannon?
If your band changes, so say you started off in the housing register on band D, and then 4 months later you go up to band B, it's the later date that will then be your new start date. So it's a start date in that current band. So your starting time wouldn't be when you first applied, it would be when you first got awarded that band. And the same often for how many bedrooms. So if suddenly your bedroom needs changed, it would again be within that band and that bedroom need. So it would like reset the timeline.
Yep. Thanks, Sharon. Next question: homes application submitted, triggers section 184. You then meet the condition for the priority, which triggers section 188. The only interim duty of accommodation available is a hotel. If you decide where you are with friends, family, so forth, does this make a difference? In other words, does going into interim accommodation speed up getting off? It shouldn't do. Legally, there's no distinction, but it does, because housing councils in general are fighting fires. They kind of, they're inundated, they can't do anything, they're losing money, and therefore they will basically do whatever saves them money quickest. So moving someone out of interim accommodation into final accommodation is going to save them money. But if you're staying with friends and family, you're not costing them anything yet. They're not motivated to actually help you out. Shannon?
Yeah, so I have a slightly different experience of this, and I might have just gotten lucky where the council actually looked favourably on the person staying in the accommodation rather than costing the council temporary accommodation. And it potentially, like the client could have potentially been intentionally homeless because the client wasn't costing the council money in temporary accommodation. I think they looked more favourably upon it. It did take longer because, you're less of a rush to be moved out. Potentially, there's that. Yeah.
I'm assuming you had the discussion with the council to say, hey, we can insist that you get that this guy gets temporary accommodation. It's going to cost you money. Shall we have a bit of a negotiation about this?
So, like, really politely, sort of pointed out that we're helping you out here for this person staying in this accommodation. So if we're helping you out here, please don't forget our client. And we chased it and stuff like that. So it's possible to still get a good result, I think, but you have to politely, and it has to be the right housing officer. And
Cool. Next one, another reasonably quick one. What should you expect when your 56-day relief period ends? If you're not in priority needs, absolutely nothing. There is nothing. The council can. Council, it's still worth making the application if you're not in priority need, because the council can sometimes help you into private rented accommodation, but they don't have to do anything. And these days that means they won't do anything. So that's just the way the relief duty works. It's not terribly helpful. Let's do. This is a question that came out of last week's one. So I was talking about template letters that council officers use, and I basically said that they're unlawful. And I think I was referring to specific cases there. But basically, the reason I'm saying templates are unlawful is, first of all, they kind of they get officers to shoehorn evidence to fit a non-priority decision or an intentional homelessness decision, or just the way they're set out. There's other things which are legal as well. But then there's this follow-up question: what if you get a letter from the council which has got details of someone else, someone else entirely? As we said last week, that's illegal in terms of it's just a data breach. That the council's not kept the other person's personal data secure, and you can get compensation for that actually. Nearly through the questions. There's two more questions that come through the week, and then we'll return to the live stream chat. So in fact, I've answered that one. So after, sorry, someone say something?
Yeah, just to clarify that, because you said they could get compensation, but it's the person whose data has been shared can get compensation, not the person who's received the data. You can't get compensation.
Yeah,
that's my
yeah,
understanding. Yeah. I just wanted to clarify that, because you made it sound like if you got the wrong information, you could claim for that, and you can't.
Yeah.
It's the person whose information it's about.
Yeah,
But
thanks,
you
Shannon.
also can't act on that information. So say you've got someone else's details, you can't sort of search them on Facebook and be like, oh, I've just learned all this from you. So
as a non-organization, I think you actually could. A professional couldn't. So because professional, you're kind of governed by the Data Protection Act, whereas just a member of the public going about their business, they could do that. So yeah, you might help someone out by saying, hey, the council just gave me your information. Do you want to go do something about it? That would potentially work. And then last one.
Can't.
Yeah, no, professionals, no, you can't. You can't be digging around on someone's Facebook, to be honest. Anyway, right, yeah, cool. Penultimate question from the week. It might be if we get this many questions again in the week, we'll just do 2 live streams. I don't know. We'll have to figure out. So what if council's homeless team is avoiding stating at what stage the application's actually at? There's no mention of prevention, relief, or full duty with any of the two within any of the 2 emails from the council. And when they ask for confirmation of the duty, the question is ignored. What if they've simply been told to find their own private rented sexual accommodation? So that is a sign. So if you're basically saying to a council, look, can you at least just confirm what's going on with my application? If they go silent about that, that's probably a good sign that they're actually breaking the law. So what you could do in this situation is do a subject access request and just basically look through your notes to see what stage things are at. And you might find that actually, the council hasn't actually done quite a lot of things it should have done at that point. Or you can complain, or you can escalate it to their boss, or copy in a councillor or an MP or something like that. All of those things would probably work. And again, if you are told the only option for you is for you to go and find private rented accommodation, but you're in priority needs, then that's definitely going to be a lie. Because although that's something you can be doing and kind of getting on with, that is not something the council has got a duty to do something. To help you out with that, or kind of source other accommodation. And then the final question, which again is something which comes up quite a lot because it's obviously quite a serious issue out there, is and it relates to actually a question we had a bit earlier in the live stream. So in fact, I'm just going to refer back to that. So we got someone who family with autistic child doing GCSE mock exams. School has basically said that they shouldn't be leaving school, but they've been basically told they've got to leave London. So again, in that same situation, that you've got a good argument to make, but you probably need a solicitor, because to actually make the argument is quite technical, and it's one of the areas which I would say it's probably one of the hardest areas for a layperson to go in and do. But council shouldn't do it. They should be promoting the well-being of the child. If the school is saying this is the kids need to be able to continue to come to this school, they've also got presumably a disability, most likely in terms of the autism, so that additional kind of need to take that into consideration. Hopefully that's enough. Right, that's all the questions that came in through the week. How are we doing on the live stream, guys? Shannon, you seem to have been watching it more than I have. So are there any other significant questions that have come up that we've got ability to answer now?
I think some people are saying, what happens if you're placed in temporary accommodation and can't afford to go private? That one, the council can't place you in somewhere that's unaffordable, because you would technically still legally be homeless. So that just shouldn't happen. And they will do like affordability assessments with you. It doesn't necessarily mean you'll get social housing though. So typically social housing is more affordable, but they might do like a discretionary housing payment. That is an option. And then I think there's something about, people just being pushed away from the council and priority need being a high sort of threshold. That's like their experiences of it. I'm not sure there's a question there. If there is a person not getting help it's a bad decision to deliberately break the law just to have a police cell over your head. Any advice? I'm not sure what that's asking.
Yeah, I mean, I think if you're asking us, should you go and commit a crime, obviously we're not going to say yes, go and do it. I have worked with people. I had a guy in Bedford. I loved him. When he was out, he'd throw a bin through the KFC window every time. But that's not in any way an advised way of doing it. And yeah, I would say don't ask questions like that, because you're not going to get you're only going to get one answer from anyone who's kind of in a professional capacity. Cool. Okay. I know there are some things we haven't going to be able to have time to go into detail in there, guys. As I say, me, Will, and Shannon will have a talk about managing this number of questions again. I did know there was a lot coming in, so I should have maybe thought about this before we started the live stream tonight, and maybe split it over 2 nights. But yeah, I think we've done our best. I think it's probably fair to say. So yeah, what I'm going to do is I'm going to use this this flip chart here thingy to kind of index the question we've answered. It would have been nice, I guess, for me to put timestamps in, but that's a step too far for this week. So yeah, anything else anyone wants to say before we go? I know, as I say,
can I just jump in? There's actually 3 very quick things I want to say. And I'll keep them quick because I know we've been going on a long time. Point number 1, I put it in the chat on our Zoom thing. But I should have said at the beginning, but I don't know if you guys saw. There was a BBC website news feature this week to say that a woman had applied to Thurrock Council as homeless and had been told and had received a letter saying that she could probably cope with the effects of homelessness and therefore wasn't going to get anything. And I thought, well, this isn't really news. This is like bears doing things in the woods, really, isn't it? It's and so I have sent a message to the journalist who wrote the article saying you're presenting this as an isolated, newsworthy incident. If you want to know more about this going on every day, do get in touch.
Yeah, that's what the template says. Yeah. I'm really happy you did that. Yeah.
What's even more frustrating as well is it's not. She doesn't seem like the most vulnerable out there. Like,
no.
These decisions are happening to the most vulnerable people. And the people that tick every priority need box imaginable, and like this is what's hit BBC News is that, rather than like the thousands and thousands of LGO cases, the thousands and thousands of perverse gatekeeping decisions. And yeah, I saw it, and whilst I completely got it and got that it's an unsympathetic and horrible letter to receive, I was also like, come on, BBC, like there's so much more to this.
Sorry, I'm just going to check out the name of the journalist, because I've
have you seen her before? Eleanor Laurie. She's up there under the picture.
No, I'm not dealt with her. I've spoke to a few BBC journalists before, but again, they're not interested in the depth of the story. But yeah, cool. Thanks.
The thing that worries me as well is that I don't know if it occurs to you, but no disrespect to Heidi Dodson, who's featured in the story, and I wish her luck and hope that she's able to challenge what sounds like a disgraceful decision. But it also occurs to me that she does look like the sort of person that the BBC might be upset about being messed around, rather than the majority of people that I deal with who get messed around. She's the right colour and she has a nice English sounding, or Germanic even sounding name, and the way that people who are sort of lower down the social order are treated is pretty shocking compared to that. But maybe it's not so shocking when it's somebody like this. The other thing I want to say was 2 things. One is that I'll fix me to one thing. A lot of the questions that come in are asking questions like, are you in priority need if? And that long one that you put on there, Mike, with all the different medical conditions. I mean, there is no yes or no answer, because it's about the council being satisfied. But my advice to people is don't give up. If you apply to the council, if the person, say, with all those medical conditions applies to a council which uses now medical, there's a very strong chance that they'll get a decision saying they're not in priority need. And then don't think to yourself, oh, those 3 people on YouTube didn't know what they were talking about, because apparently you're not in priority need. Do challenge it. I had one yesterday where this is I had 2 records. This is the last thing. Yesterday, I got somebody from Barnet had approached me, and she'd applied to Barnet Council, elderly lady, doesn't speak very much English, bad medical condition. She applied for Barnet for accommodation in March last year. They didn't give her anything. She's been sofa surfing. This year she says, look, I've really been asked to leave where I'm staying. So they give her a negative priority need decision based on, we asked you whether you've got a medical condition. You didn't seem to think you had, so you're not in priority need. No inquiries. So I requested a review yesterday, and to the credit of the reviewing officer at Barnet, I was out somewhere in the evening and I got an email saying we've withdrawn the decision. It's about 7 o'clock. So that was within a few hours. And then today I made a formal complaint to Lewisham Council via their website because I hadn't been getting responses to emails about somebody whose relief duty had ended. And I was writing to them saying, do you accept that you now owe her a full duty? And nothing came in, but I put a complaint on the website at about 11 o'clock. I got an email this afternoon from the client saying, I've just received a Section 184 notice from the council accepting a duty. So it shows that these things do work. If you either threaten a legal challenge and or make a complaint, then it does make a difference. And don't give up and don't be put off by negative decisions or people ignoring you. So that's the end of my.
Yeah, and I mean, in the training we do, I actually copy in a now medical letter, decision letter, and everyone just is outraged by it because it's just not worth anything. And you've got basically a doctor who never meets the person, never speaks to the person, never sees their medical records, just coming up with any old shit just to they get paid, and that's the end of it. So I kind of tell people in the training, don't get put off by it. Basically,
go back to the BBC thing. The Heidi Dodson, if Now Medical get hold of her case, she should not be put off. I mean, in the article it says that because she's a 56-year-old woman, they should be treating her as vulnerable, but that wouldn't get very far with the sorts of people we're dealing with. But it may be that she has medical conditions and may even be able to show that being 56 might work. So nobody should give up, despite horrible decisions you may get.
Thing was also interesting because this is law in Wales, Scotland, one of the two.
Wales, probably.
Wales. So it mentions that actually she spent time rough sleeping as a teenager for 5 years. And so that would be relevant in priority need, particularly in Wales. I mean, in the Code of Guidance, it mentions a history of rough sleeping. So as a reason for potentially being in priority need. So it's not that she's not in priority need. I guess it's just that we often see
people
cases.
Significantly more evidence, and they still use exactly the same terminology. I mean, they're just quoting the HOTAC case. That's all it is. So so the chapter 8 of the Code of Guidance, the one Shannon's just talking about there is 8.40, history of sleeping rough being relevant to it. So do read that through. And if you go on this channel, like if you search for trauma, homelessness and priority needs, there's a full event there which kind of goes into a lot of detail. And it's one of the things I'm most proud of ever done, really, to be honest. That was a really good event. It's also got a barrister explaining vulnerability in taking about half an hour of it, so a lot more time than we have. And also, again, if you just check out the channel, if you search for Section 184 on the channel, you would get a video which is like 3 judges explain Section 184 or something like that. So let's go back to 2020, and there's basically three judges basically explaining how low these thresholds are. So housing officers break the law all over the country. Often they don't even seem to realize they're doing it. They're just so institutionalized, and they look around and everyone else is doing it, so they think it's all right. Much like the post office stuff going on at the moment. I'm still fixed on it. But that's what you're up against. So I think just as general principles, exposing it and expanding who's actually looking at it, getting it outside the housing team is one of the best things you can do. So getting a councillor involved, getting an MP involved, meeting with them, taking time to kind of explain the situation to them is a really good move. So we will be back next week, guys. Will and Shannon, you both here next week?
Yes.
Yeah, cool. Back to 7:30, and if we get a load of questions coming again, we'll maybe split it up or something. I don't know. So all right, guys, take it easy. Hope this has been helpful, and good luck in all your different fights. Don't stop fighting, baby.